Hello, my name is Michael Tesoro and I prepared this video note entitled Are You Kidding? Or AER-U-kidding? And I'm going to talk about a couple of things. Firstly, the decision Colvin in AER and EnergyAustralia, which is, in my view, a very poor decision. And also just some of the practices that I've seen AER adopting in relation to their activities, which just don't make much sense to me. A bit of background about myself. I'm a competition consumer lawyer. I've been running my own practice to Tesoro Legal Consulting for about 14 years. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including enforcement and mergers. Never worked in the access area, which was what it was called back when I was there. So I don't have any specific expertise in that particular area. Outline of the presentation, I'll start with the introduction, then the background to this particular case, then look at Colvin's decision, and then what I call some other curiosities about the way AER do their work, and finally some commentary. And the background of this case is that EnergyAustralia admitted to breaching the national energy retail rules in relation to the registration of life support equipment. So under the rules, there's an obligation on energy providers to register that a person residing at a particular premise requires life support equipment. Also, they've got to notify a distributor of a person on life support at a particular premise. Then they also have to provide emergency telephone numbers for the distributor to customers when registering the premises. And finally, there's an obligation under Part 7 to establish policies, systems and procedures for the registration and deregistration of premises requiring life support equipment. Now, clearly this is an important law. It's important in a few respects. Obviously, if a premise is not registered as a premise where there is somebody needing life support, then if there's a disconnection of those premises, the person could die. So the benefits of registration is that people will get a notification of any planned disconnection and be able to move to another location where they'll have access to electricity. So it's very important law or rule. And also, there are provisions which prevent a person from being disconnected from their energy source for non-payment of the bill. Because clearly, if a person who's on life support is disconnected for non-payment, then they potentially could die. So these are really important rules, and they're really focused on the preservation of people's lives. So it doesn't get more serious than that. So EnergyAustralia admitted that it breached the relevant rules on a number of occasions and agreed a settlement with the AER to pay a fine. Now, Colvin looked at the agreed facts that were put to him and noted that there had been thousands of breaches of the law, up to 14,000 contraventions of the law. And not only were there significant number of breaches, but the breaches occurred over a lengthy period of time, like from July 2018 to July 2020. But of more concern was when the conduct was reported to the AER by EnergyAustralia, there was this long delay in actually fixing the problem. It wasn't a case that the conduct was alerted to the AER and then fixed immediately. There was a long day, very significant delays in providing the required information to the regulator. So at this stage, you've got a life-threatening breach affecting 14,000 separate premises and a large number of individuals going for a very lengthy period of time. Then Colvin also noted in paragraph 18 that this conduct went to the very top senior management of EnergyAustralia. The senior managers of EnergyAustralia did not give sufficient care and attention to compliance with the life support equipment provisions. And they were slow once they had identified there was a problem in taking decisive steps to remedy the problem. So this is even more serious conduct because it goes to the top senior management of EnergyAustralia. Then Colvin comments that EnergyAustralia has now undertaken significant changes to its systems. It spent $6.5 million to automate its system to remove the potential for error, and has a dedicated life support team. But this can't give EnergyAustralia any credit whatsoever, given these laws have been around for a lengthy period of time, and all of these steps should have been implemented years ago. So Colvin concludes that the contraventions were serious in terms of the number of contraventions, how long they were occurring, that they involved life-threatening issues, vulnerable consumers are being exposed. He concluded that conduct wasn't deliberate, but you'd have to think that they're reckless, which is pretty much akin to the same mental culpability as being deliberate. And then he says, somewhat surprisingly, that the conduct actually isn't that bad because there was no identifiable financial or other loss or injury to consumers. So you've got this very, very serious breach, and the judge is seeking to find some arguments to say that it's actually not that serious after all. And then he says that there was no financial benefit to EnergyAustralia from the failure to implement this law or these rules, which again seems inconsistent with what has been said earlier, because now EnergyAustralia has spent $6.5 million establishing the systems which they should have established many years before. So that appears to me to be a clear financial benefit to EnergyAustralia. So this paragraph didn't make a lot of sense to me. Then Colvin states that any penalty needs to be sufficient to deter EnergyAustralia and other parties from engaging in these breaches. That's clearly the correct statement of principle. But then there's this very odd observation. In part, that means looking to the costs that are necessary to be invested in order to comply. A penalty which does not reflect the extent of those costs would be insufficient. Now, I've never heard of that principle before. It's totally out of left field. The cost of complying with the law is somehow a relevant consideration in working out the level of penalty. So I don't understand that, and I don't think it's actually a statement of any principle of law that I've ever heard before in the calculation of civil pecuniary penalties. So Colvin decides that a $12 million penalty is sufficient to achieve a specific and general deterrence. Now let's have a look at the penalties for breaching these rules. Firstly, for failing to register the premises, it's $100,000 for each contravention. Then there's a further penalty of $10,000 for every day that the breach continues. So let's have a look at the number of breaches. There's 14,000 contraventions, and there are 92 occasions where the delay in registration was in excess of 50 days. So they're the sort of the baseline figures. So let's do some maths now. You've got $100,000 multiplied by 14,000 contraventions, which gives you a maximum fine of $1.4 billion. Then you've got 10,000 multiplied by 92 premises multiplied by 50 days. You've got an extra $46 million worth of maximum penalties. So the total maximum penalty is at least $1.446 billion. And you've got to contrast that with an actual penalty of $12 million. So when you do the division and the multiplication there, that equates to a penalty of 0.8%. So the penalty imposed in this case is 0.8% of the maximum penalty which could have been imposed for this conduct. That's a ridiculously low penalty. Do some more maths. We'll look at EnergyAustralia's annual revenue, which the court found was $5.6 billion a year. And if you do the maths there, you realise that $12 million represents a penalty of 0.2% of EnergyAustralia's annual revenue. Again, hardly the type of penalty that's going to achieve any specific or general deterrence. Now, it seems to me that Colvin didn't note the recent High Court decision in ABCC v Pattinson, which clearly establishes the goal of civil pecuniary penalty provisions, which is solely the promotion of public interest in compliance with the provisions of legislation by achieving deterrence. And so when you're setting a penalty in a civil penalty provision, you've got to be looking at what number is necessary to achieve specific and general deterrence. Now, this case isn't even referred to in Colvin's decision. It did come out in April. Colvin's decision came out after. And the question is, are these penalties that have been imposed in this case by Colvin going to achieve any specific or general deterrence? I'd say not likely. Another omission from the case or the judgment is no reference to Makarian v. the Queen, which seems to be a standard case that is referred to in civil penalty proceeding cases. Now, Makarian's a criminal case, but it does establish the principles that have to be looked at. And I don't think the High Court said that this case shouldn't be looked at. In Pattinson, they didn't say that Makarian is no longer to be considered when setting civil pecuniary penalties. So clearly, careful attention has to be given to the maximum penalties because the legislature has legislated them. They're saying that you need to work out what the maximum penalty is so you can work out whether the penalty imposed is going to achieve any general deterrence. Well, here, in this case, not only has Colvin not mentioned Makarian at all in his judgment, which only goes for 7 pages, by the way, but there's no attempt to work out what the maximum penalty would be for EnergyAustralia's conduct, which seems to me to be contrary to the case law. You've got to at least work out the maximum penalty and then compare the agreed penalty with the maximum penalty and conclude whether that's going to achieve specific general deterrence. Well, I would submit that Colvin hasn't done any of this analysis in his judgment. Now, just moving on to another area, and this is in relation to AER's authority to approve companies as retailers either in gas or electricity generation. Now, they've got a retailer authorization guideline which is issued in December 2014, and what AER do is they look at the financial organizational capacity of companies to become retail energy providers, but they also look at the person or corporation's reputation. So they're effectively working out whether they're a fit and proper person to be issued an authorization to be a gas or electricity retailer. And it's all spelled out in their guidelines. And clearly they're looking at whether there's a degree of honesty and integrity shown in the commercial dealings, and also whether there's any improper conduct. The guidelines go on to say that they're going to look at any material failure by the applicant to comply with regulatory requirements, laws and obligations over the previous 10 years. So clearly, in order to be a fit and proper person, the previous history of the applicant is going to be under scrutiny. Here we have AER and EnergyAustralia. EnergyAustralia has just been fined $12 million for a serious breach of the life support equipment provisions of the rules. Previously, they paid $1.2 million penalty in ACCC action for unlawful sales tactics, and also fined just a couple of years ago by AER $80,000 for switching customers without their consent. So the question is EnergyAustralia still a fit and proper person to hold an energy retailer license? Now, there's an argument they're not, and there is also, at the very least, an expectation that EnergyAustralia will review EnergyAustralia's fitness and propriety to hold such a license. But comparatively speaking, EnergyAustralia are by no means the worst. Origin Energy applied in 2021 for a gas retailer authorization, and that was granted by AER. AER concluded, and there's an extract from the letter which AER sent to Origin saying that they believe they demonstrated the capacity and suitability to operate as an energy retailer under the retail law. There's no reference to anything else. That's simply the extent of the discussion of their suitability. Let's have a look at Origin Energy's compliance record. 2021, the Queensland Competition Authority took action against Origin, forcing them to reimburse fees charged electricity consumers which they shouldn't have charged. 2021, they pay a penalty for sending disconnection warnings by text message. 2020, they get in trouble along with EnergyAustralia and Toto for breaches of metering rules. In 2020, AER issues them with 6 infringement notices for breaching the National Energy Retail Rules. 2020, Origin Energy pays a penalty for misleading electricity consumers following an ACCC action. 2019, New South Wales EPA fines Origin Energy for dust emissions for its Erring power station. 2019, AER gets a court enforceable undertaking out of Origin Energy for de-energisation of 54 small businesses. 2019, AER issues another 6 infringement notices to Origin Energy. There's more. 2018, Essential Services Commission takes action against Origin Energy for incorrectly recovering undercharges from customers. 2017, Origin Energy is fined by the AER $40,000 for wrongful disconnection and failure to provide hardship assistance. 2017, AER issues another infringement notice for a breach of the National Energy Retail Law. 2017, 2 more infringement notices to Origin Energy. 2016, Origin Energy pays a penalty for the alleged failure to follow dispatch instruction. 2016, another infringement notice issued by AER. 2015, Origin pays $2 million for unlawful door-to-door sales following ACCC action. In 2014, court orders penalties of $8.3 million against Origin for the Sydney forklift gas cartel, which was a hardcore long-term cartel that had considerable impact on the Sydney market. So you've got all these breaches over the last number of years, less than 10 years. This is less than 10 years. But then you have AER granting them an authorisation to be a gas retailer on the basis that they're a fit and proper person, that they meet the requirements of the legislation and they're suitable. There's simply no way that that conclusion follows from this compliance record. Another recent one was on the 22nd of October 2021. AER agreed to issue Telstra Energy, which is a subsidiary of Telstra, with a gas retailer authorisation. And again, AER's concluded that they have the capacity and suitability, i.e. they're a fit and proper person to operate as a gas retailer. They also issue a decision to approve Telstra Energy as an electricity retailer under the rules. They're obviously a suitable, fit and proper person there. Now, this is following the ACCC's action against Telstra, whereby they're fined $50 million for engaging in unconscionable conduct towards Indigenous consumers. So it's a few months later, the AER's concluded that Telstra are a fit and proper person, despite them having engaged in this unconscionable conduct where they're selling products to Indigenous consumers that they can't afford. They're taking advantage of the fact that these consumers can't speak English. They're taking advantage of their social, language, literacy and cultural vulnerabilities, exploiting those vulnerabilities. Robert Sims goes on and says that this is probably the worst unconscionable conduct the ACCC's ever seen. It's worse than the Coles unconscionable conduct case from 2014-15, where they were forcing suppliers to pay them amounts of money. He says that this is much worse because of the exploitation of these vulnerabilities, the stress and anxiety that they put these Indigenous consumers under. The people were in great fear, and in 70% of cases, Telstra sent these debts, which had never been incurred, into the hands of debt collectors. So here we have a very, very egregious breach of the law, which AER has taken no notice of in concluding whether Telstra is a fit and proper person to hold an electricity and a gas licence. So I guess what I'm saying here is that AER has really got it wrong numerous times. Not only should it never have settled the EnergyAustralia case with EnergyAustralia for $12 million, which is absolute peanuts given the seriousness of the contravention, the number of consumers who are affected, the number of contraventions involved, the fact that senior management were responsible for the conduct and it went for so long. $12 million is simply inappropriate. It is not going to achieve any specific or general deterrence. A penalty of 0.8%, the maximum fine, or 0.2% of EnergyAustralia's turnover is not going to achieve specific general deterrence. So why is AER settling cases that are of such a serious nature with large players for peanuts? Secondly, the court should never have accepted this settlement. This settlement was totally inadequate to achieve any outcomes. The failure by the judge to write more than 7 pages, to consider the relevant case law, to consider Macarian, to consider the ABCCV Pattinson case, the failure to really work out a maximum value of this contravention and then compare the settlement amount with that amount. These are all errors, serious errors, that should not really be occurring. And so, put simply, the court should have rejected this settlement and not signed off on it. And this settlement is not ticking any of the boxes for an appropriate settlement to achieve any general or specific deterrence. The further observation is the AER needs to improve its act, pick up its act, because you can't be authorising companies to be electricity and gas retailers on the basis they're fit and proper people, fit and proper corporations, when they breach the law time and time again. Origin Energy has 16 breaches in the last 10 years that I was able to find. EnergyAustralia has 3. Telstra has had one of the worst cases that the ACCC has ever run, clearly the worst unconscionable conduct case that it's ever seen based on what Rod Sims has said. So I think the AER needs to be serious about the authority that it has to only approve companies that are fit and proper, that haven't breached laws on a regular basis, and make the hard decision of saying to these companies that they're not fit and proper people and revoking their authorization. Now, if the legislation means anything, it means that it's got to be applied appropriately, and clearly it's not being applied appropriately at the moment. And I guess one added comment is I have assisted some companies who have sought to apply for authorization under these provisions, and they have been given a very hard time by AER, who's been digging up every possible contravention they could find for these small companies while turning a blind eye to the big companies, and that's just not appropriate whatsoever. That's all I had. I'm a bit worked up about this particular case because it's just such a terrible case, such terrible conduct, and effectively EnergyAustralia has got away with it, paid a very small fine. I'm pretty sure they would have had a big celebration when that decision was handed down, because it is just such a slap on the wrist, and AER has to stop approving large companies as fit and proper people when there is absolutely no evidence that they are. They're engaging in multiple serious breaches of legislation. So it's a call out to the AER to improve its performance immediately, because it's just not good enough. So if you've got any questions, feel free to give us a call or drop us an email. Bye-bye.